Begin this morning with major developments over the last 24 hours for workers at one of Houston's top-notch hospitals, Texas Children's. We first broke the story Tuesday about a physician's assistant who spent more than $20,000 to move here and work for Texas Children's. She got here and found out there was no job due to a hiring freeze. Then hours later, the hospital announced it was letting some 1,000 people go. What recourse do you have legally for either scenario? That's the question we're asking this morning. Employment attorney Gregg Rosenberg is joining me this hour. Greg, thank you so much for your time. I want to start with our physician assistant here. The situation that she's in. She's now suing for, I believe it's $400,000. She says the hospital admitted knowing it was under a hiring freeze well before her start date, but never gave her a heads up. Does anyone at an at-will state like Texas have a legal case when it comes to something like this happening?
So the question really is what was told to her at the beginning of all of this. She's alleging, I actually read the lawsuit yesterday, and she's alleging that they should have known that the hiring freeze was in place before they hired her. But unless you have an express agreement with the employer before you come, this lady, my understanding was, came from California. Unless you have an express agreement before you come that the job will be there and there's no provision for termination other than the typical for cause, it presents a big problem where Texas is an at-will state, which means an employer can hire or fire for a good reason, a bad reason, or no reason at all, even at the inception. So the employee is presumed to know that she's coming in to an at-will situation that can terminate at any time. Unfortunately for her, this came at a horrible time.
So she does not have one of those agreements you're talking about? From your
I
understanding.
didn't see it in the lawsuit, so obviously I don't represent this lady. I didn't see it in a lawsuit. If it was in a lawsuit, if she had an agreement, it certainly would have been pled in a lawsuit, and it wasn't.
And so therefore, it's going to be very challenging for her to prove.
I think so. Yeah. She pled a few different theories. One is called promissory estoppel. I've been doing this for 38 years. I've tried that before. It simply doesn't work in Texas. It's kind of a detrimental reliance theory. And the theories, the case law in Texas has been very, very clear in support of the continuation of the at-will doctrine. Very, very few exceptions to it. One thing I think she pled in the lawsuit was fraud. She'd have to prove that Texas Children's was intending to defraud her at the inception of this deal, and that, quite honestly, doesn't make logical sense to me.
Interesting. So, Greg, in situations like this, what can people do to protect themselves on the front end? Is there certain language that they should petition to have put into that offer letter?
Sure. Well, all of these offer letters are going to always have a disclaimer on them that nothing in the agreement supersedes the at-will nature of employment. But what I tell people to do when people are consulting me to leave a position to go to another position, and it doesn't have to be across the country. This lady came from California. It could be across the street. If you're leaving a company that you've worked at for a period of time and you're happy there and you're going to another company, you want to get an assurance in writing, because that would be an express agreement that circumvents or overrides the at-will nature of the employment agreement. Typically I tell people you try to negotiate a deal for a year, 2 years that limits the employer's ability to terminate other than for cause, like if you commit a crime or something, like that. But that's what we call an express agreement to the contrary that takes these things out of the at-will doctrine. And that's the best, not only the best, but the only thing you could do. You've got to get an agreement that overrides it. Now, employers hesitate to do that. And then my advice to the employee who's looking to go anywhere is make sure that the grass is really as green as you think it is on the other side of the street, because it may not be.
Yeah. Great perspective, good advice. Greg, since breaking this story, we've heard from a lot of folks who work over there. And so we're getting a broader picture here, a broader scenario. Some 1,000 people allegedly are getting laid off because a nonprofit is struggling financially. Legally, is there anything those workers can do?
Well, the story I saw last night on Channel 2, the nurse, I think she was from Austin, she said something about a contract. Now, I've represented a lot of nurses over the years at various institutions, and I've never seen a contract that overrides the at-will doctrine for a nurse or a nurse practitioner or a physician's assistant or anything like that. Generally, these when a company like Texas Children's or any major employer undergoes a reduction force, a massive reduction force, this was huge. They're generally going to vet it out with their attorneys to make sure they're not violating any protected rights, such as mostly an age bias. Make sure it's not a gender claim. Make sure it's not religious discrimination. Any of the protected classes. The most prominent ones in these reduction forces are age, and we have what's called the Older Workers Benefit Protection Act, and these employers generally vet out to make sure there's no age bias in there. Very, very difficult to bring an individual retaliation or discrimination case on a mass layoff, because you'd have to prove that you were picked for the layoff in deference to somebody else because of, for example, a disability, a perceived disability, or religion or race. But you were the same race and religion when they hired you, and here's a massive layoff and you're involved in it. Very difficult. Sometimes you could look at it at a case-by-case basis, but very difficult in a mass layoff like that.
Okay. Thank you so much for your time this morning, Gregg Rosenberg. We appreciate it.